So we also encourage you to engage with this webinar on social media using the hashtag #JusticeForRohingya, which you see here on the screen. To get us started, I'm going to briefly frame this discussion. Starting in October 2016 and then again in August 2017, Myanmar security forces engaged in so-called clearance operations against the Rohingya, a distinct Muslim ethnic minority in Rakhine State. The operations, in particular those that started in August 2017, were characterized by brutal violence and serious human rights violations on a mass scale, including rape and other forms of sexual violence, indiscriminate killings, arbitrary detention, torture, beatings, and forced displacement. These acts followed decades of systematic discrimination and persecution of the Rohingya, including passage of laws that stripped them of their citizenship, restricted their religious freedoms, as well as their reproductive and marital rights. In September 2019, the UN fact-finding mission concluded that the state of Myanmar breached its obligation not to commit genocide and found that Myanmar continues to harbor genocidal intent against the Rohingya. Then, in November 2019, the Gambia filed a case against Myanmar at the International Court of Justice for violations of the Genocide Convention, and in January, the court issued provisional measures in the case to protect the Rohingya from genocide and preserve evidence related as the case progresses. In addition, recognizing the extraordinary urgency and importance of the measures ordered, the Icj asked Myanmar to submit a report on its compliance on the order on May 23, 2020, and then every 6 months thereafter until the case is decided, which brings us to the subject of today's discussion. While we have not seen Myanmar's report to the court, and its contents may remain confidential, since January, Myanmar has ostensibly taken some steps aimed at complying with the orders, including presidential directives to ensure officials do not commit genocide, to prohibit the destruction or removal of evidence of genocide, and to prevent incitement and proliferation of hate speech. Recently issued, there is little evidence to demonstrate that these directives have been or will be meaningfully implemented. They also come against the backdrop of a global pandemic, escalating conflict in Rakhine, which is effectively excluded from the military's recent unilateral ceasefire, a looming national election, and recently failed attempts to reform the constitution and reduce the military's role in the civilian government. Recent domestic efforts at criminal accountability, notably the work of the Independent Commission of Inquiry, are neither independent nor impartial and do not provide a pathway for genuine accountability. And none of the steps taken by Myanmar touch on the long-standing structural discrimination against the Rohingya, nor provide a basis for their safe, voluntary, and dignified repatriation, all of which will be discussed in further detail by our panelists today. I'm going to conclude by noting that the court's order importantly recognized that the Rohingya in Myanmar remain extremely vulnerable, and that Myanmar has not presented to the court concrete measures aimed specifically at recognizing and ensuring the right of the Rohingya to exist as a protected group under the Genocide Convention. This is the lens through which the court will be looking at Myanmar's compliance, as should the international community. And with that, I'm going to turn it over to our distinguished and brilliant panelists to begin the discussion. We're going to first hear from Professor Yang-Hee Lee. Professor Lee served as a member of the Committee on the Rights of the Child from 2003 to 2013, and as its chair for 2 terms from 2007 to 2011. She was the guiding force in drafting, negotiating, and adopting the 3rd optional protocol to the CRC. And in addition, she has served as the chairperson of the Coordinating Committee of the Special Procedures of the United Nations Human Rights Council, as well as the chairpersons of treaty bodies. And of course, most relevant, she was, until about 2 weeks ago, the Special Rapporteur on the situation of human rights in Myanmar, a role she held since 2014. In this role, she was instrumental in establishing the fact-finding mission and the independent investigative mechanism on Myanmar, and an unwavering voice for the people of Burma. Professor Lee, over to you. You are on mute still.
I thought you were going to unmute me.
Yes.
Thank you. Now you can hear me. Okay, thank you. Okay. I would first like to thank the 3 organizers for hosting and inviting me to this fantastic panel. It is such an honor and privilege to be speaking on this panel with former Ambassador Vanda Nassum, whom I have great respect for, and Uwe Wu, who has been very dear to me during the past 6 years of my mandate. The importance of this panel is that it is being held as Myanmar's first report on its compliance to the ICJ orders is due on the 23rd of May. Sadly, today marks 1,000 days since 25 August of 2017. And more sadly, no progress at all. Today I will speak about the current situation in Myanmar and hopefully provide some ideas on how Myanmar can effectively comply with the ICJ's order. As you all know, ICJ unanimously indicated the following provisional measures. I will not read out all the provisional measures, but most importantly, it has to take measures within its power to prevent the commission of all acts within the scope of the Genocide Convention. And the second order was to not commit any acts described in the above point number 1. And the third order was to take effective measures to prevent the destruction and ensure the preservation of the evidence related to all allegations of acts within the scope of Article 2 of the Genocide Convention. And of course, the fourth order was to submit a report within 4 months and then every 6 months thereafter. I would like to address points 1 and 3. However, in order to do this, I will need to give you some recent updates that have direct or indirect relationship to these points. According to the information provided to me by many sources, between mid-March and mid-May, there were at least 167 armed clashes in civilian areas or direct attacks on civilians by armed actors across 4 states and 1 region of Myanmar. These actions resulted in at least 99 civilian deaths, 255 civilian injuries, 209 civilians abducted or detained, 61 civilians tortured, 1,017 homes destroyed, and 2,200 people displaced, at least temporarily, if not permanently. I'm going to give you some information about what's happening around these areas. Chin State reported 35 deaths, 3 abducted, disappeared, 7 air drone strikes, 13 armed clashes, 4 attacks, and 1 incident of property destruction. Cayenne State reported 2 deaths, 13 armed clashes, 1 attack, 3 incidents of property destruction, and 12 incidents of shelling. Rakhine State had the largest number of deaths, 80 deaths, 1 abducted, 9 air drone strikes, 40 armed clashes, 33 attacks, 1 incident of property destruction, 16 shelling incidents, and 1 incident involving grenades. Saigon region had 2 armed clashes. Shan State reported 17 deaths, 2 abducted, 8 armed clashes, 5 attacks, 1 incident of property destruction, and 1 incident involving grenades. This is all happening with the backdrop of the COVID-19 pandemic. This data is presented so that you can have a general idea that the atrocities that are happening are not only happening in Rakhine State against the Rohingya only. However, the Rohingya are still facing the brunt of the military violations and abuses. For the sake of time, I cannot give you all the different incidents, so I will raise only a few incidents. On 10 March, 3 Rohingya died from shelling in Nimbia Township. 22 March, 6 Rohingya youths were injured from a shelling reportedly coming from the Navy in Choctaw. 11 May, 2 women and 1 16-year-old woman were severely injured, and another 3 received minor injuries due to artillery shelling after an explosion near Kanadi Bridge in Choctaw. Recently, no Rohingya villages were burned. The ethnic Rakhines are now facing hardships. It is ironic to see the similarities between what had happened during 2016 and 2017 to the Rohingya are now happening to the ethnic Rakhines and other ethnic minorities. 18 March, there was a report that the Tatmadaw put an old couple into a burning house to die. The military had disappeared, arrested, tortured, or killed dozens of men after burning up to 700 homes in Tinma village in Choctaw on 22nd March. 10 men disappeared. One man was found shot and decapitated. Bodies were later located in a nearby river. 5 April, an 84-year-old disabled woman was reportedly put in a burning house alive after being decapitated first. In one artillery attack on 13 April, the Tatmadaw killed 8 civilians, including at least 2 children, when it targeted Choksek village in Panyawan Village Township with artillery from its nearby Battalion 550 base. 16 May, 194 villages and 1 middle school in a Rakhine village was burned. Reportedly, soldiers from Light Infantry Division 44 set fire to the house. Just over the weekend on 16 May, 200 houses were burned in Lekhar village in Murahu. The continued shelling, missile attacks, and air drone attacks are contributing to the third provisional measures to prevent the destruction and ensuring the preservation of evidence related to the allegations of acts within the scope of Article 2 of the Genocide Convention. Deaths of Rohingya resulting in the attacks and shellings directly relate to the first provisional measure to prevent commission of all acts within the scope of Article 2. Now the question is, how can Myanmar comply with ICJ? It is clear how Myanmar can comply with orders. First and foremost, stop violence, stop discrimination and persecution. Although there was a recent presidential order to abide by the ICJ orders, which can be viewed as an attempt to comply, but how will they be enforced? Myanmar needs legislation that incorporates the Genocide Convention into its domestic law. This is a requirement under the convention. Another way is to generally implement the Kofi Annan Commission recommendations, a roadmap for Rakhine. That will allow Rohingya to return safely. It seems like people are forgetting that the burden lies on Myanmar to create the conditions for return, and the Rohingya cannot stay in Bangladesh indefinitely. Has anyone seen the full report of the government-established independent commission of inquiry? The commission found that war crimes, serious human rights violations and violations of domestic law took place in northern Rakhine after 25 August 2017. And the Judge Advocate General and Attorney General are now reportedly undertaking further investigation. It is entirely doubtful that the most responsible will ever be held accountable, as war crimes do not exist within the Myanmar's domestic law. Furthermore, under the Defense Services Act of 1959, the only human rights violations that are criminalized are murder, culpable homicide, and rape, and these failed to cover all that occurred. Provisions in the Constitution that grant jurisdiction over crimes committed by the military exclusively to military tribunals, from which there is no prospect of appeal, and guarantee military personal immunity for prosecutions for acts done before 2011 should be reformed. Additionally, the crimes that constitute human rights violations committed by the military under the jurisdiction of civilian courts there must be amendments to the Defense Services Act so that these violations will go under the jurisdiction of the civilian courts. International crimes, including war crimes, crimes against humanity, and genocide, must be legislated in the domestic criminal law. Moreover, the justice system must be reformed to avoid victims of human rights violations and effective remedies such that full and effective reparations are made, including restitution, compensation, rehabilitation, satisfaction, and guarantees of non-occurrence. I repeatedly underscored the need to bring the entire government and security forces under civilian control and initiate extensive legal reforms, including the Constitution, land laws, citizenship law, and laws that violate fundamental rights such as freedom of expression, assembly, and religion. Numerous calls were made for the international community to ensure that Myanmar dismantles the system of discrimination against the Rohingya by law, policy, and practices that continue to exist and guarantee fundamental human rights to them, including by restoring their citizenship rights and property. If I have a few more moments, I would like to raise a few more points that we need to consider within this backdrop of this pandemic of COVID-19. First of all, the humanitarian aid restrictions and the internet shutdown since 2019 January. The order has continued at that order that the government had instructed the United Nations and international humanitarian organizations to suspend all activities except for the World Food Program and the ICRC in the 5 townships in Rakhine affected by the conflict. That order has continued and is a violation of international humanitarian law. The government must ensure humanitarian access to people in need of life-saving assistance. The mobile internet shutdown affects the rights of over 1 million people and is terribly concerning as it severely reduces individuals' abilities to access necessary information in the context of escalating armed conflict as well as COVID-19. SIM card registration period ended at the end of April. For those without NVCs, it is impossible to even purchase a SIM card. As most of the Rohingya currently do not have NVCs, they will not be able to use their mobile phone during this very crucial time. The recent discovery, and the second point I'd like to make is the recent discovery of the World Food Program products in the AA area. The military asserted that it had found the counts when undertaking security operations near the Bangladesh border, as it had received tips that the Arakan Rohingya Salvation Army was planning attacks to provoke the Tatmadaw in advance of Myanmar needing to submit its report to the International Court of Justice in May. Deja vu almost. This is very concerning as it could lead to a crackdown on Rohingya civilians under the cover of a security imperative, despite the fact that security forces have been ordered by the court not to commit acts listed in Article 2 of the Genocide Convention against any group. The third point is journalists in hiding. On 23 March, the government declared the Arakan Army a terrorist group under the counterterrorism law. That law contains very broad provisions and there is very little oversight of how it is applied. Following the declaration, Naranja and Voice of the Myanmar news outlets conducted interviews with the members of the Arakan Army. The editors of those outlets were charged under counterterrorism law, and the editor of Voice of Myanmar was arrested. He was later released, and it's believed that the charges against him have been dropped. However, the editors of Naranjara and Kipkit are in hiding in fear of their arrest. The offices of Naranjara have been raided, and journalists have gone into hiding as they fear they could be arrested clearly for working for that outlet. The censorship order. In March, for the first time, the government imposed a censorship order on all internet service providers in Myanmar. But when most of the websites were ordered to because of their pornographic or child abuse sites, there were a number of media sites. These included news sites run by ethnic groups. This is of serious concern, the right to freedom and access to information in the context of ongoing crackdown on the media in Myanmar. but also significantly during the COVID-19 crisis, ongoing armed conflict, and the elections that are scheduled for later this year. The final point I'd like to raise is that of the technical involvement in COVID-19 response. In March, the president announced the formation of a new committee to deal with the government's response to COVID-19. It is headed by the military-appointed vice president and includes the military and the three military-controlled ministries, as well as several other civilian-controlled ministries. This provides the military with a significant role in the government's response to the pandemic, in particular enforcing community quarantines. This collaboration between the government and the military has not been seen before in the NLD administration period, and points to the military's increasing power and influence. Thank you for your attention.
You are still on unmute, Akila.
Can you hear me? Okay, sorry, I apologize. We were going reasonably smoothly with technology. Thank you so much, Professor Lee, for that clear and detailed analysis of the current context in Myanmar and really what we need to be looking at and how the international community should be viewing any representations by the country. We're next going to hear from Ambassador Letitia van den Assem, a diplomatic expert who is a former Dutch ambassador and also served as a member of the Rakhine Advisory Commission headed by Kofi Annan. Ambassador van Assem? There you are.
First, I've been getting messages from people who are saying that they registered late, and they're still awaiting a password so that they can join us. So if your technology wizards can look at that, that would be
I will
great.
send a message to the technology wizards while you're presenting.
Thank you. Okay. Well, let me say, of course, first that I'm honored to be part of this panel with people that I really value very highly. And I know many of you in the audience as well, and I'm very delighted that so many of you are participating. My thoughts are very much at the moment actually in Bangladesh and in northern Rakhine State, because we're waiting for the news about the typhoon that is landing, and I'm hoping and praying that everyone will be all right. We know the risks. Going back to the first session of the first hearings of the International Court of Justice on the 10th of from 10 to 12 of December, I was in Southeast Asia at the time, and but I was actually with a group of Rohingya women. It was total coincidence that at the time that we were meeting, the hearings were also taking place. But it was a real privilege to be with them, to watch the hearings and to get their immediate reactions, which varied from elation to anger. So a very wide range of emotions. And to me, that underlined the importance that we all tread very carefully when we're dealing with the issue of justice and accountability, which is so important. We should not focus only on the issue of accountability and justice, no matter how important it is, because when you meet with Rohingya, when you speak with them, and when you are with them, like I was fortunate to be when the hearings were ongoing, you realize that justice and accountability have to be contextualized. They have to be seen as a part of much larger problems that they're facing. The trauma, the great concern, the sadness about relatives and friends that they've lost, the deep worry that they will now be having about relatives and friends that are in northern Rakhine State and in Cox's Bazar is really important. And you can only try to address the justice issue if you bear that in mind. So, of course, I'm acutely aware that justice and accountability really are only two of the critical elements of a wider process to deliver sustainable transformation. And that is also how I approach today's event. Accountability and justice as part of wider issues. I embrace the international justice process, but continue to look at what else is needed to achieve ultimate stability, peace, and development that everyone craves for. In that context, you know, in light of the importance of that broader context, I'm somewhat disappointed about the attitude of some in the international community who now give the impression that, well, you know, the criminal accountability question is now with the international lawyers. That is fine. Now we can go and turn our minds to other pressing issues. If you do that, you know, you negate the comprehensive approach that is so desperately needed. And we're seeing some of that, not with everyone in the international community, but with some of them. Now, looking at the measures that Myanmar's government has announced as part of its efforts to comply with the provisional measures, I would like to be able to accept them as genuine. But there are so many credibility issues. If you, like many of us do, follow on a day-to-day basis, the many atrocities, the war crimes, the crimes against humanity that Yang Li has just spoken about are ongoing as just at the time as the government is making these small steps and that are intended to show their seriousness. You have a credibility issue. You have a real credibility issue. One example, and I think Yang Li also mentioned, this is a directive to all state employees to refrain from genocidal acts. That was issued without a proper explanation of what such acts might be. And that's really important because genocide is about much more than mass killing. It is still largely not properly understood what the different elements of genocide can be. It is not only about mass killing, it's also about the slower and much more pernicious acts that do not give a group room to breathe, but instead marginalize them, deprive them of healthcare and education, give them insufficient food rations, and house them in shabby temporary camps that were built in 2012 and were only meant to last for a maximum of 4 or 5 years. We're now 8 years on. And just yesterday, I was really struck by the announcement that was made that the Department of Health is going to stop child immunization programs in Rakhine State, particularly for outlying villages, for security reasons. I was horrified by that because decades of worldwide experience have shown us that even in case of conflicts, serious conflicts, efforts are made to allow these basic health issues related to children to give them priority. But that's not the case in Myanmar, not for COVID-19 and not for children's health needs. Let me say something also about, because I mentioned the different elements of genocide, about the acts of commission, like mass killing, but also the acts of omission. And acts of omission are where the government has not acted to repeal discriminatory legislation or remove administrative directives that directly affect the Rohingya. Among the most important acts, I think, of omission is the system of enforced ethnic segregation or apartheid that is still in place. It is very much in place. Nothing has been done. And I have not seen any indication that the government is planning to do something about it. I think that would be of serious interest to the court. Another one, for example, is the neglect in dealing with the highly discriminatory race and religion laws of 2015. That is something that the government could do. I know it's probably going to be contentious, but it could at least say we are going to have a serious conversation about ending about repealing these highly discriminatory race and religion acts, and also dealing with enforced ethnic segregation, which is a crime against humanity. If the government were to act on these, it would indicate seriousness on its part to comply with the provisional measures. We don't, of course, know, as you indicated, whether we will ever see what is in what is in the government's report, but I suspect it might issue a press release because it would probably also want to be seen domestically as acting on these kinds of issues. Now, as I indicated, I'm very interested in the bigger context and in solutions. And in this context, I want to draw the attention of everyone to a remarkable report that was released in March that does not only provide important analysis of the situation of Rakhine, but also gives a wide range of recommendations that are sensible and doable. The report I'm speaking of is Freedom of Movement in Rakhine State, prepared by the IRI, or Independent Rakhine Initiative. And that initiative is owned by 6 INGOs working in Rakhine State. The report does what the Annan Commission in 2017 had recommended that the government do, and that is to undertake a mapping process of all restrictions of movement in Rakhine, not only restrictions on the Rohingya, but on all communities. That mapping process has now been completed. And not only that, we now also have suggestions for a detailed roadmap for the short term, medium term, and longer term to lift the restrictions. And it's very pragmatic. It doesn't say you have to lift everything and the restrictions at once. It realizes that some things can be done in the short term, other in the medium term, and others again in the longer term to lift all these restrictions. And some of these recommendations really go to the heart of what I see as genocidal process, particularly enforced ethnic segregation or apartheid. 2 final points, if I may. One is a concern that I have about the ICJ and witness protection. We know the case before the ICJ is not a criminal case. It's a case between state parties that deals with criminal issues in this particular case. There have been not many cases before the ICJ where we've seen witnesses appear, but they did appear in the case of Bosnia-Herzegovina v. Serbia a number of years ago. But I know that I worked in other countries where there were issues, but more related to the ICC and witness protection. And I want to make sure that everyone who is working on these kinds of issues related to the ICJ starts to think about what may need to be done in order to ensure that if and when witnesses are asked to appear, that they are protected. It could become a real issue. It's not yet. Final point, what we have to do, I think, is think about ways of diffusing the potential for perceived differential treatment of Rohingya and other groups, notably the Rakhine. What in the case of the Rohingya which is now a protected group, can be construed as part of a genocidal process, may in the case of the Rakhine and all others perhaps be war crimes and crimes against humanity. But they don't have the same recourse, they wouldn't have the same recourse that the Rohingya had. It is unfortunate in the way that over the years, the general perception is that genocide is the crime of crimes and therefore the highest of crimes. That was never perhaps the intention of the drafters of the convention, but that's a reality that we have to deal with, and we have to find ways of making clear that this is not a case of differential treatment, that crimes against humanity and war crimes are taken with equal seriousness. Thank you.
Thank you so much, Ambassador van den Essem. I think your presentation really highlights what was at the core of the Rakhine Advisory Commission, which is that you need a comprehensive and systematic approach to addressing the situation of Rakhine State, and that you need to see Myanmar's government make genuine efforts at it. And thank you as well for highlighting the need to address impunity for crimes committed against other ethnic groups. I think that is a conversation that is often missing from the larger focus of the international community. And we're finally going to turn it over to Weiwei Nu, a former political prisoner and the founder and executive director of Women Peace Network in Myanmar. Weiwei spent 7 years as a political prisoner in Burma because of her father's pro-democracy political activism. Since her release from prison in 2012, she's dedicated herself to working for democracy and human rights, particularly on behalf of marginalized women and members of her own ethnic group, the Rohingya. Weiwei.
Thank you, Akila, and the organizers for the opportunity to speak on this timely and critical issue. And also thanks to those joining us from all around the world. And it is an honor to speak on the same panel with Professor Yang He and Ambassador Letitia. And so it has been 5 months since the World Court recognized the Rohingya as protected groups and ordered the Myanmar government to end its genocidal acts against my community. And it is again so disheartening that 5 months has passed, but no meaningful and genuine actions have been taken to end the violations, policies, and practices that led to the forcible displacement of over 800,000 Rohingya in 2017 and many more before that. Added to their already fragile situations, the Rohingya are now facing the challenge of COVID-19. Of course, typhoon is coming soon, and whether at the sea in search of safety and dignity in neighboring countries, only to be turned away to the open sea, and inside Myanmar, informal and formal IDP camps living in apartheid-like condition, and in Bangladesh, where the first cases of COVID-19 have recently been confirmed as fires tears through the refugee camps, described as tinderbox of spread of the pandemic. And so in Myanmar, the President's office has issued various statements and directives, as Professor Yang He and Ambassador Letitia has mentioned, including to those in government and military not to commit acts that prohibited by the Genocide Convention, and for the civilian to stop using hate speech and on social media. But they are lacked transparency and never disclosing any information to the public as what they are actually doing in compliance with the preliminary measures, and it's been really unclear what is going on with the government. And on the ground, what has changed for my community? What changes have we seen yet? These lofty statements have not translated into any meaningful differences for the life of the Rohingya. So I would lay out a few points, a few reality in the ground, in addition to what the Professor Yang He and Ambassador Letitia described. Rohingya and other IDPs in Rakhine State remain in open prison camps with no rights to freedom of movement, no human rights, living on meager humanitarian aid as government continue to restrict aid organization to from accessing from the camps and deprive of healthcare and food security. And while basic human rights have not been seen secured for the Rohingya, now the government plans to close down IDP camps. It is concerning that the objective of the strategy to close down IDP camps do not even include returning the IDPs to their places of origin. And providing compensations for their losses. Instead, they plan to create the permanent the camp near the existing IDP camps that will only further entrench the segregations without freedom of movement. And this is not the solutions. This will only create further problem and segregations. And we deserve the same rights as those who are free, in other part of the world or in other citizens in the country in Myanmar. The future of our youth also should not base on accepting deeply problematic national verification card that has been used as a tool of genocide. So recently, Center for Diversity and National Harmony, with the funding from European countries, facilitated about 40 Rohingya students among many thousands Rohingya students to attend universities in Yangon. But they were not made to choose between accepting NVC or not being able to further their educations. So these are not genuine attempts as creating equal opportunities for Rohingya to obtain their educations or restoring their rights. International governments should ensure that such problems do not further entrench segregations and discriminations by first consulting with the consulting and listening to the Rohingya themselves. If such problems are meant to provide opportunities for our future, it should not come at the expense of our identity and ethnicity. Even more concerning, the security forces has continued to run villages actually in Butidong and Maungdaw, which include houses of my grandparents in Butidong, which is Mitongze village in Butidong. So they have been recently they have been continued burning houses and villages in northern Rakhine State. At the same time, just a week ago, the government announced that it is supposedly stopping Rohingya villages from being taken by settlers that have moved into the previously lived on by the Rohingya. But on the other hand, the Myanmar government has continued to erect the government building on top of the Rohingya villages, which were raised by the Myanmar military in 2017. During the most annual presidential amnesty for prisoners, the government allowed about the release of 800,000 Rohingya, which include women and children who were arbitrarily detained for traveling from Rakhine to other parts of Myanmar. Aside from the fact that their rights to freedom of movement should never have been restricted in the first place, there are still thousands of Rohingya remains in the prisons in Rakhine State. These Rohingya must be given legal protections if government is serious about complying the preliminary measures. And government ministries continue to refer the Rohingya by the racist, this derogatory term Bengali. For example, Ministry of Labor, Immigrations and Populations on 6 April directed the release of these Rohingya detainees. Except they repeatedly refer to the Rohingya as Bengali. So how can Rohingya in Bangladesh return to the country, to a country, to deny our existence and uphold laws such as 1982 citizenship law that denied the Rohingya citizenship, fundamental rights. Regarding the citizenship, the national verification card process lies at the root of persecutions of Rohingya. It's emblematic of the systemic campaign by the Myanmar authorities to erase our identity. As long as government continue to promote an administrative process that effectively strip us of our basic rights, as those belong to Myanmar, our rights are not secure and we're not free. These are conditions under the government that's going to hold elections in November. And while our political rights of the Rohingya have not been restored, they will once again have no voting rights and no participations in these elections. So this is an urgent need for political dialogue to ensure the participations of Rohingya, and the government must effectively end policies that disenfranchise Rohingya while improving the situations in the ground. Finally, despite the directive by the ICJ, the Myanmar military continue to act with complete impunity, as Professor Yang He described, with being praised by the government for their job well done. So the civilian war between the Rakhine army and Myanmar military has only escalated since ICJ hearing in January, and during this COVID-19 time. The attack by the Myanmar military have reached intensity leading to the civilian casualties not seen in years, since 2017. And worse, the internet continued to restrict it in 8 townships in Rakhine and Rakhine State, making it even more difficult for the IDPs to access information on how to protect themselves from this global pandemic. So as as Professor Yang He pointed out, the Myanmar military attack against the civilian in Rakhine State needs and investigations into allegations of ongoing war crimes and crimes against humanity in accordance to the international standards. International crimes continue to be committed on the very ground that genocide against Rohingya took place. While government has yet to even allow international independent investigation to take place or allowed the international independent mechanisms on Myanmar, IIMM, access to ensure that evidence of grave crimes are not destroyed. So this is the very area where government has said they are working towards ending the acts of genocide. If Myanmar is to comply with the ICJ's order to prevent genocide, they must urgently focus on concrete steps to amend or repeal discriminatory and repressive laws and policies that target and disenfranchise Rohingya, and need to provide necessary legal protections. It is imperative to achieve justice for Rohingya, and this is not only meaningful to us, but to other ethnic minorities who have also suffered grave crimes over the past decades. The ICJ opens door to end decades-long impunity of Myanmar military, bring justice to those who have been long persecuted and deny their rights for generations. Justice for Rohingya is just more than recognizing that physical harm was committed against us, as Ambassador Letitia mentioned. Yes, we suffered deep physical wound, but the pain and suffering linger our collective soul. So we need holistic justice for the Rohingya to restore humanity. The world must use this moment as an opportunity to end generation-long and difficult suffering of Rohingya and restore their rights and dignity as human beings. So their very survival of the Rohingya may depend on this. Thank you very much.
Thank you so much, Wei Wei, for the powerful reminder that sometimes that the things that happen at the international level when orders are passed, that it doesn't actually have an immediate impact or improve the situations that we're talking about. So I think that bringing that human dimension to these often academic conversations is so incredibly important. And also the powerful reminder of the need to act, you know, immediately as it relates to the disenfranchisement of the Rohingya and the upcoming elections. And how that can, you know, that's going to further the political isolation. So between the three of you, I think we've gotten quite a robust summary of what meaningful actions by Myanmar's government could look like. And as we move into Q&A, I will say we have about 10 minutes left, 400 participants, and I've got about 5 pages of questions. And so I'm going to take a little bit of moderator's privilege here and combine a question to start us off with that I think will get to many of what people are asking for, which is, we focused a lot on what Myanmar can do. I think a lot of what's also going on in Myanmar has been characterized by the dysfunction of the international community, the failure of the Security Council to act, the inability to have a singular voice out of the UN system and a consensus on what needs to happen. So if each of you were to say that there are 3 steps that the international community should prioritize to take in assessing compliance and how this influences how they engage Myanmar's government, what would they be? And we'll go in the order of the speaker. So Professor Lee, you first.
Oh, wow. 3 steps. First and foremost, the international community should stand together, not put their own or other interests above the interest of the people of Myanmar, in order to get some definite change made. And the Security Council, you know, we've been talking about it a lot throughout the years, how dysfunctional it is. And I think that is where the greatest reform must take place. All over the world, we're seeing reform, but we're not seeing any reform in the true meaningful sense in the UN system and in the Security Council in particular. The final step would be when we, in the international community, when we are reviewing and monitoring human rights standards or footprints of a country, we always call, as Ambassador Letitia Assam said, accountability. We shouldn't focus only on accountability, but I would like to say in a different way that we call on accountability for perpetrators, be it people, government, the military. But what about the accountability of the UN system? What about the accountability of the international community? Who's there to call for that? And I think it's time that we need to really do some heavy restructuring of our minds and our discourse, and to see and to demand the UN system, the Security Council, in most particular, for accountability. What is their mandate? Have they been true to their mandate? I think those are the 3 steps. I have been a little bit bold, and I know Ambassador has been in the UN system as an ambassador, and so she may have a different view. Thank you.
Thank you so much. Ambassador Ranganathan?
Yes, sort of sprung that on me, but it is important. I think that I fully agree with Jan about the importance of the international community standing together. And I think, sometimes you have to look at the positive. It's true that, the members of the Security Council, at least, some amongst them, China and Russia notably, have stopped any action. But what we've seen, and that is very positive, we've seen that the General Assembly, sort of a uniting for peace way, has actually said, okay, if you don't do it, we'll do it. And we've seen a lot of action also with the systems of work started in the Human Rights Council, and then endorsed by the General Assembly, with a majority on average of 138 to 140 of all countries voting, present and voting, which is very, very high. Mm-hmm. So there is a strong mandate. Look at the Gambia. The Gambia is acting for some 57 members of the Organization of Islamic Cooperation. So that, but other groups are very disappointing, notably ASEAN. And I think that much more needs to be done in terms of pressure and discussions with the members of ASEAN, what they can actually do. Because at the moment, what you see is with the sad situation of the Rohingya taking to the high seas again, and with the problems of labor migration, there are such important issues that directly affect ASEAN. They can no longer say it's a Myanmar problem and a Bangladesh problem, it's not us. So that's important. Secondly, what I would say is the recommendation, take seriously the recommendation by the fact-finding mission that all countries should tell their business community to be very clear about their due diligence before they invest and cooperate with Myanmar companies, and make sure that these are not controlled by or owned by the military. That's a very pragmatic step. We're all in favor of investment, but not through these kinds of companies. And thirdly, I think we have to be, raise our voices even higher when it comes to the overall issues of diversity and ethnicity in Myanmar, not only related to Rakhine State, not only related to the Rohingya and the Rakhine, but in Myanmar generally. This is what is holding Myanmar back. And it will not be able to move forward until it accepts its minorities and accepts that diversity is its strength.
Thank you so much. And Weiwei.
Thank you. So the three things that I would like to recommend is the first thing, the first and the most important ask is that for the international community to recognize the root causes and the crime as it is. And take actions by joining ICJ or practicing universal jurisdictions or reviewing their economic engagement with the Myanmar military, and or acting at the UN Security Council by referring the case at the ICC or establishing an ad hoc tribunal to really speed up the processes, because we cannot let people wait for for several more years by suffering in these squalid IDP camps. So we need to speed up and take actions, recognize the crimes and take actions immediately. And secondly, the international communities or Myanmar government must listen to Rohingya. People say you don't have leaders, you don't have representative. I would say that is wrong. We have many leaders and representative. We have 2 political parties in Yangon, and we have political leaders in Myanmar. And we have in refugee camps and in IDP camps, we have camp representatives, and we have activists. We have many representatives. That should not be an excuse. You need to listen to us and talk to us, and encourage Burmese government to talk to the Rohingya directly and involve them in the implementation processes of, Kofi Annan Commission's recommendations or fact-finding missions recommendations or the provisional measures. So the listening and talking and involving participations of the Rohingyas are essential to have really like sustainable solutions or impactful solutions for the Rohingya. The last call will be uplifting Rohingya, supporting Rohingya directly in the ground by investing them in educations, in economy, and by any means uplifting Rohingya is a long-term the solutions that we need to start investing on. International governments and donors has spent billions of money to support the Rohingya, but in reality the Rohingyas' lives on the grounds remain the same. So there should be focusing on the programming of these long-term like investment, such as skill-based programs or educations or economic empowerment.
Great. Thank you so much, Wei Wei. And with one question, we've actually reached the end of our time. But what's clear to me from the engagement in this conversation and listening to these 3 brilliant women talk is that there is so much more to discuss and to be said. And I think it speaks to the need to address a solution to the crisis in Rakhine and overall in Myanmar with much more of a layer of complexity than the conversation is often approached with. And so I want to thank the panelists for highlighting what some of these top levels are. I know that all of us as organizers will go back and think through how to continue this conversation as this moves forward. This is one part of a much larger conversation we have, and we're all now trapped at home. So maybe there's more opportunities to have this type of engagement. I also want to really thank my co-organizers, and in particular, Pampreet Singh from Human Rights Watch, Nadira Court and Simon Adams from the Global Center on the Responsibility to Protect, and Grant Shubin from the Global Justice Center, who are not on the screen here, but were instrumental in making this happen. As all of you have articulated, the international community needs to use all the tools within its power to hold Myanmar to a high standard of compliance with the ICJ's Provisional Measures Order. After all, as we all remember, the order provisional measures from the ICJ in the Bosnia case happened with the Srebrenica genocide happening 2 years after the first orders were measured. And so it's imperative that we continue to work diligently to resolve this crisis, because what happened in Srebrenica cannot be allowed to happen here. The lives of over 600,000 Rohingya still living in Rakhine State and over 1 million in Cox's Bazar depends on it. Thank you all so much for joining us today, and we look forward to continuing the conversation.
Thank you.
Bye-bye.
Bye-bye.
Bye.